disguise, the judge opens by cutting straight through the excuses and exposing the core failure in this case. Completing services didn't matter when the court clearly saw the mother still couldn't meet her children's basic needs now or in the future.
But although Ms. Bushman might have logistically gotten some things together, she has not convinced this court that she can provide for the needs of the children now and in the future. Court finds that she has completed services on her family plan of service, but she has not met the goal of the service plan of being able to meet the needs of the children. Court finds that she was not able to stop vaping, and she was smoking for a certain point of time. Court finds that she was not able to maintain a safe and stable household while the children were in her care. They were removed from her care, not once, but twice during the life of this case. And the court finds that even long after inpatient drug treatment, she still had a positive drug result from. Court finds that this case was initiated due to use and neglect. Court finds that Ms. Bushman has not only minimized the health issues throughout the case, but her very behaviors and reactions, including her own testimony in this trial, was that she believed everyone else was making a bigger deal about the medical concerns than was necessary. She reacted to Ms. Swallow's closing argument in a manner that I could only infer to this minute was that the children's health issues to her are not as severe as all of the professionals and the experts testified. This is of great concern to the court for the future safety and needs of the children now, again, and in the future. That's a best interest factor that I cannot ignore. No length of stability in an apartment or a job can overcome such a startling fact. The court observed Ms. Bushman nodding her head when it was mentioned that the breathing treatments were causing the children to have problems, which is further evidence to the court that she does not take the diagnoses of the children by medical professionals and therapists seriously. That is of great concern to the court regarding her ability to parent in the future when there's no supervision on her care or the physical needs of the children. The court finds that Ms. Bushman endangered the children, and then throughout the course of this case has shown through her specific acts and omissions that she continued smoking and vaping during the case despite the knowledge of the children having chronic lung disease. And despite that knowledge, she has minimized their medical diagnoses and conditions. She did not seek intensive and thorough medical intervention during her monitored return. She went to one doctor's visit. She made the decision after that one doctor's visit to take the children, who it's been testified to and is not in dispute, are silent aspirators, off their thickener based on that one physician's examination. Despite her being made well aware throughout the course of this case that they needed speech therapy and swallow studies to make sure they were getting adequate treatment for their condition. Court finds that the children are bonded to the foster parents and have a safe, stable, appropriate placement that meets their needs. The court finds that the court-appointed special advocate has the same concerns after making approximately 10 visits and observing the mother with the children. The court-appointed special advocate testified that there's a pattern in the mother's behavior of failing to put the children's needs before her own. Court finds that the court-appointed special advocate had concerns about Ms. Bushman's long-term ability to care for the children, and she pointed out that sobriety doesn't always equal a safe and stable home. The court finds that the disparity of income between the mother, Ms. Bushman, or the father, Mr. Martin, and the foster parents has absolutely no bearing on this decision. In that regard, the court has only considered the ability to provide the children with a safe, stable, drug-free home that can meet their needs based on the evidence presented. The court finds by clear and convincing evidence that the department and Belong made reasonable efforts to return the children to the parent before the commencement of a trial on the merits. And despite those reasonable efforts, a continuing danger remains in the home that prevents the return of the child to the parent. That continuing danger be what I just laid out in my previous findings. Court specifically finds we just lost somebody. Who did we leave? Who did we lose? Was it Mr. Martin?
Yes.
All right. Well, we'll see if we can get him back, but I'm going to keep going.
The judge walks through every reunification effort already attempted and why each one failed. Safety plans, monitored returns, extended chances. This moment makes it clear the system tried, and the risk still remained too high. How many chances is enough before the court has to stop trying?
Court specifically finds that those reasonable efforts include returning the children to the parent and attempting to avoid a removal by utilizing a safety plan and supervision resources, developing a family plan of service narrowly tailored to address the concerns that brought the children into the care of department and belong, attempting a monitored return to the mother in this case that failed based on the specific acts and omissions of the mother, and requesting the court to extend the case to allow the mother an additional monitored return, which the court has denied as stated in the court's findings and rulings in this final order. The court finds that the interveners have proved by clear and convincing evidence that both parents, Tracy Bushman and Corey Martin, have, pursuant to Chapter 161.001 B1, have knowingly placed or knowingly allowed the children to remain in conditions or surroundings which endangered the physical or emotional well-being of the children, engaged in conduct or knowingly placed the children with persons who engaged in conduct which endangered the physical or emotional well-being of the children, failed to support the children in accordance with the parent's ability during a period of 1 year ending within 6 months of the date of the filing of the petition. For the mother, for both parents, been the cause of the child being addicted to alcohol or a controlled substance other than a controlled substance legally obtained by prescription. That's for both parents. And then for the father, the court will additionally find that Mr. Martin constructively abandoned the child who has been in the permanent or temporary managed conservatorship of the Department of Family Protective Services for not less than 6 months, and the department has made reasonable efforts to return the child to the parent. The parent is not regularly visited or maintained significant contact with the child, and the parent has demonstrated an inability to provide the child with a safe environment. And Mr. Martin also failed to comply with the provisions of a court order that specifically established the actions necessary for the parent to obtain the return of the child who has been in the permanent or temporary managed conservatorship of the Department of Family Protective Services for not less than 9 months as a result of the child's removal from the parent under Chapter 262 for the abuse or neglect of the child. Additionally, for the mother, court finds that the interveners have proved by clear and convincing evidence, pursuant to Chapter 161.001B, that under P, she used a controlled substance as defined by Chapter 481 Health and Safety Code in a manner that endangered the health or the safety of the child and after completion of a court-ordered substance abuse treatment program, continue to abuse a controlled substance. For the purposes of the record, the statute provisions for the father are 161.001 B1D, E, F, N, and O. And for the mother, there are 161.001 B1D, E, F, P, and R. Court further finds that these terminations of parents' parental rights pursuant to these provisions of the statute proved by clear and convincing evidence are in the best interest of the children, and it's in the best interest to terminate the parental rights of both parents. The attorneys for the parents, Ms. Savage and Ms. Pearsall, are dismissed. Court finds that they have satisfactorily completed their duties. The attorney ad litem, Ms. Harris, and CASA advocate are maintained in their respective appointments for relationships to the court. We'll have a permanency review after final order, October the 8th, 2024 at 10 a.m. October 8th, 2024 at 10 a.m. Court finds that placement of the children with the foster parents is safe, appropriate, meeting their needs, and in their best interest to continue.
This is the final and most serious moment as the judge formally terminates both parents' rights under the law. The ruling isn't emotional. It's decisive, final, and focused solely on the children's long-term safety and future stability. Like the video, subscribe, and we'll see you in the next one. Do you agree with the termination, or should the court have given one last chance?